Yes, Mr. Secretary.
Item number 16,
16.
it's the appeal filed by the state.
Hmm.
My only prayer with the consent of the other side, could it be taken a little bit early, Lords, around maybe 11:30, 12? I'm requesting for, my prayer is for upgrading the matter. I have some difficulty in the second half.
Just a minute. Details. So it's a point. খুশি মতো নহব ন লিষ্টখনটো আগতে ওলাইছে তো ভালটো নহয় ঠিক আছে হ'ব যেতিয়া অন হ'ব তেতিয়া অন কৰিব এতিয়ালৈকে লিংক দি দিম will take up around 11:30.
Lordship, briefly obliged.
May I please, Lordship? My lord, this is a writ petition for motion. Last year, 3 times it was listed, but due to
Not reached.
paucity of time, it was not reached. Tomorrow, obliged.
May I please, your Lordship?
With the consent of the other side, I beg to mention item number 17, Lordship. The Lordship may kindly take up this matter after vacation, Lordship.
Declare the conflict for the parties list referencing verification on date to be fixed by the officer.
Interim is there, that may be continued.
If interim is there,
Yes, fine.
it will be on 23rd.
23rd. Oblige, my lord.
So, victim item 5, Lordship. Engaging counsel, DA crime is out of station, Lordship. Let me pass it for the day, Lordship.
After vacation date. Ensuing verification.
Obliged.
May I please, Lordship, I beg to mention item number 6, 7, and 8, Lordship. Can you pass over the matter for a day, Lordship?
After vacation.
Yes, Lordship.
Declare the conflict for the parties.
May it please, Lordship? Lordship, I beg to mention one WPC for listing. Lordship, on last date, the matter was left over due to paucity of court time.
This will come
If
for
possible,
motion, admission
kindly-
orders, what?
Lordship,
The matter will come for motion, admission.
admission, Lordship.
Admission.
LCR is already received. Lordship, if possible, on 4th of April.
May I please, Lordship? I beg to mention item number 10 and 11, minute.
Hmm.
After Bihu, minute.
24th.
Obliged. 24.
May I please, your Lordship? Lordship, with the consent of the other side, I beg to mention item number 15 for adjournment, Lordship.
1-5.
Yes, Lordship.
1-5. Okay. Referencing verification. Declare Mr. I. Chapman, counsel for the petition.
Obliged.
My please, your Lordship. Lordship, this case pertains to an incident dated 26 December 2023, wherein a young youth named Dipankar Gogoi allegedly committed suicide. Why I'm saying allegedly, that I will come later on. But what led to his death is on 22nd, 23rd, and 24th and 25th of December, the Titaborh and Jorhat Sadar police took away Dipankar Gogoi from his home into his illegal custody and tortured him brutally, given him 3rd degree, and the respondent number 2, who is Mohanlal Meena, threatened him for self-implication in a different case and put his service revolver into his head and said that if he doesn't take the if he doesn't own the case of that Lichubari bomb blast, then he will be killed. So after the incident of suicide, the sister of the deceased lodged an FIR in Titaborh police station, which is FIR number 132 of 2023. Thereafter, investigation took place and WSI Nirupama Das was appointed as the IO. But suddenly, the final report was submitted by an inspector. The change of the IO was never informed to the informant as well as the deceased party. So in the final report, it was stated that it was a mistake. It was a mistake of fact, and the case was requested for closure. But the IO did not take into consideration the postmortem report, which clearly indicates torture into the deceased. Also, Your Lordship, there are several other incidents like evidences which states that the deceased was allegedly tortured. He was taken into the police station. He was taken into Titapur police station. He was taken into the Jorhat Sadar police station. He was also taken into the official bungalow of the SP of Jorhat. These facts were not mentioned in the final report. So after the final report was submitted, the subdivision judicial magistrate of Titapur ordered for reinvestigation of the entire case. Even after the order of the reinvestigation, till date, a proper reinvestigation has not been conducted by the Assam police. Therefore, my prayer to this honorable court for a CBI inquiry into this entire incident.
By name party করিলা যে by name party করিলা যে by name party
By name, what's individually voice?
SP গেলে party করে না করিব লাগিছে
change voice.
তাহলে তো প্রেজেন্ট SP party করিব লাগিছে
Two presidents speak voice.
না এটা নহয় না he already transfer now present
Two presidents speak voice.
মনে করিব লাগিছে DP को पार्टी को बुलाए भाई से कौन आगे even people आगे DP is the authority head and SP is the president no no he is not controlling more no position তো আমার ভুল হয়েছে এটা কবে লাগবে এটা চলো আমার ব্যক্তিগত তো ভালো বিজেপি পার্টি করে আছেন প্রেজেন্ট এসপি পার্টি করে পুরানা এসপি তো থ্রুদি করেছে দ্যাট ইজ নট ভুল হয়েছে আর ওই ঘন্টা বাইনাম করিব না লাগিছিল ভুল হইব ভালো আছে মিনা কোথায় হ্যাঁ মহিনা বিজেপি পার্টি করে লাগে প্রেজেন্ট এসপি পার্টি করে লাগে
After further investigation, what happened?
Nothing has happened so far. No arrest, no interrogation, nothing. Even after further investigation, the respondent number 2 has been promoted.
Lordship,
Mr.
so, Lordship, so
Sharma.
he is not make the party present SP, my lord. Present SP is necessary, not make the party present SP now. Now, Mohanlal Meena, he is already transferred. He make him by
That
name.
is why, Your Lordship, I have
I have not made the party. Your lordship
made
see,
it through the
even
superintendent
DGP
police.
also, he not made the party DGP also. And present SP is necessary here, my lord.
Definitely.
Yes, he make the party
Your Lordship, I
Mohanlal
have written
Meena.
through the superintendent of police. Job.
That is different thing. He already transferred to
Then I will,
Bombay now.
Your Lordship, if it
File
directs,
appropriate application for.
then I will amend the memo of parties if the Your Lordship
DGP
directs.
is also necessary here, my lord.
Do one thing.
Mohanlal Meena, my lord, already transferred to Bombay now. No, he is not promoted. He is the.
He has been promoted to some scale. Pay scale has been promoted.
But in the same post. He is SP.
No, he is a
Try
SP,
to
but he has been
understand
promoted.
that proper adjudication of this case, these parties are necessary.
Yes.
If you do not want to make them parties, you will be knowing the outcome very well. And Mr. AMY Zwadar, counsel for the petitioner. And Mr. P. Sharma, plenary senior government Assam. Appearing for the opposite party number, for the respondent number 1. After going to this petition, we are of the opinion that Director of General Police Assam, as well as the Superintendent of Police Jorhat, are necessary parties for proper adjudication of this case. As such, the petitioner may file appropriate application for implement of Director General of Police Assam as well as the Superintendent of Police Jorhat as party respondents number 6 and 7 in this writ petition. Further, the respond number 1 shall place the visceral report of the deceased that was sent to the FSL. FSL report of the viscera of the deceased, as well as the final postmortem report of the deceased counsel before the court on the next date of listing of the matter. After filing such application for incorporation of the response.
Your Lordship, in the meantime, notices be issued to the other respondents.
First, you file appropriate application.
Then Your Lordship, then please give a short date.
We will consider immediately.
Please give a short date.
We are not giving any date. We first file implement application.
Lordship.
Made please, Lordship. My lord, I refer to order dated 6/3/2025.
What is your correct?
Heard Mr. MSA Clarence Council appearing for the petition. And who is appearing for Union of India? What's your good name? Yes. And Mr. P.S. Versatile and CGC for the response number 1. Also heard Mr. Tripang, Standing Council, Home and Political Department of the and Standing Council NRC Assam for the respondent numbers 2, 3, and 6. Mr. P. Sharma, additional representative for the respondent number 4. And Mr. M. Colita, Planet Council on behalf of MSP Bolwa PARUAT, Standing Council ECI for the respondent. Call for the records of case number FD within bracket 8 GLP 1862015 as well as from the office of the Foreigners Tribunal 8 Walpara as well as the records of case number FT within bracket Z-4 bracket was 539/2016 from the office of the Foreigners Tribunal 4 Walpara. In original record, original. Placed on 25th April. Same what case what happened.
My lord, further proceeding in
When
16
you have
case.
all the records in original, where will be the further?
My lord, oblige.
My lord. Record was called for. My interim was supposed to be considered today, my lord.
Let us.
Record is not received by.
Have you perused the records? Mr. Frank,
But
have you perused the record?
the record is not there, madam.
Record has just reached. Record has just reached. So if you want to go through the record, we'll take up next. We'll have it on 21st itself. No, sorry. We'll have it on 7th, Monday next.
All right. Don't I may be protected in the meantime?
Wait till 7, nothing
My
will,
lord, my lord.
nothing will. Person to the order dated 12/03/2025. The registry received the record of B.F.T. Case number 128/3016 from the office of the Fairness Tribunal number 2, Bopo. Just now. View the Mr. Zepang, standing counsel, open political. May go to the same list this matter on 7th for motion.
Great.
Take your seats.
My lord.
So after 1970, it is 97.
My lord.
Where is the written statement?
My lord, this is page number 23.
Kindly read para 2.
That the parents, forefathers of the opposite party were Indian citizens by birth, and they were original inhabitants of village Chalakura, NC River Block, under PS South Salmara, previously Dhubri, subdivision Dhubri, and district Dhubri, the then Gwalpara, Assam, the OP. The opposite party was born there in the year 1971 and brought up there till her marriage. The names of her parents and grandparents are given below.
Para 3.
That letter on the parents of the opposite party along with the family members shifted to Molandubi, post office Molandubi, PS Golakganj, district Dhubri, Assam, and settled there permanently.
So, as per the statement of the proceeding,
My lord.
she was there at village Salakura, non-cadastral river block,
My lord.
since her birth till her marriage.
Mhm.
Right?
My lord.
Now please come straight to page number 50, that is the Kabil number. of your read petition.
My lord.
You can read the vernaculars?
Yes, my lord.
Okay. Read number 2. What is her address?
Molandubi.
Molandu.
Molandubi.
Where she was prior to her marriage, till her marriage, where she was?
In the statement, she wrote that till her marriage.
Till her marriage, she was at where?
My lord.
Till her marriage, where she was?
She said in Chalakura.
But where is the address of the village in
Molan-
this Kabil Nama?
Molandubi.
So, where is the illegality on the part of the tribunal when discarded this particular Kabil Nama? Forget about the other reasons. Or Dane, Sali, Dane.
This particular
This
statement.
is on the basis of the statement of the proceeding and nothing else.
No, no, this particular statement was not flagged by the learned tribunal.
Doesn't matter. Raise before you.
Yes, my lord.
Because just see the discrepancies. She categorically stated,
My lord.
born, brought up till her marriage
My
at
lord.
Salakura.
My lord.
And later their parents shifted to
My lord.
Malandubi. But here is your Kabil Nama
My lord.
specifically mentioned, the address is Malandubi.
No, but this particular.
See, basically, you have to place certain documents because
lord.
this is the particular document by which you want to place your link with your projected father.
My lord. My lord.
Whether this document is to be accepted, is there any illegality on the part of the tribunal in not accepting this Kabilnama of the proceeding?
My lord, may I say this, my lord?
Yes.
This the person who issued this Kavinnama, my lord, he appeared before the learned tribunal, my lord. Page number 72, my lord. Page number 72.
Kindly read. He stated that somebody from the bride's family have written this
I
statement.
will read the entire part, my lord. Let me read the entire part. He said, I am the MMR and Kazi of Panbari Rangamati district in Dhubri. I have received the notice summon of this court to depose before the tribunal today. Along with the notice, I have received a copy of the Kabin Nama, Exhibit A of the marriage of the OP. I have verified the Exhibit A with my official record and found the same to be identical. I have
Yes.
brought the official record today with me in respect to Exhibit A. I have also brought the appointment letter of the Qazi with me. The marriage has been registered with respect to the OP and her husband in my office. All the details regarding the father's name, address, witness are entered in the register and all such particulars are same in the Exhibit A, Mila. Now the cross, Mila. The office of Qazi is situated at my residence at Panbari, Rangamati, the Dhubri district. My jurisdiction include Alamganj, Gauripur, Dhubri, etc. There is no staff in my office. I am working as Qazi for about 50 years. I cannot remember who has written the contents of the Exhibit A, but I can say that somebody belonging to the bridegroom has written the same. I have signed in Exhibit A the content of the register with the
respect copy of the OP has been written in the residence of the bride of the OP. The exhibit A is the same as the register which I have brought today. It is not a fact that I have deposed falsely today. Now there are one important point here, my lord, that this document is genuine. Now, my lord, with regard to who wrote this, my lord, he was there. And now during the Kaji, during the Muslim marriage, my lord, the Kaji is entrusted with a lot of responsibilities. Now, if he says that, okay, one person should write it under his supervision, that does not make this document doubtful, my lord.
Mr. Aman, you have been considering, you have been continuously doing these cases. You are aware.
My lord,
Now, if the prosecutor herself states before the tribunal
my lord,
in her written statement as well in her evidence
my lord,
that she was born and brought up at village A.
my lord,
She stayed there till her marriage at village A.
my lord,
And later, the parents of the
my lord,
proceeding shifted to village X.
my lord,
Now, a Kabilnama placed before the tribunal,
my lord,
which has been proved by the Kaji,
my lord,
but the address of the proceeding is of village X, not of village A, which the proceeding have placed before the tribunal in her written statement as well as in her evidence,
My lord.
stating that
My
she got married while she was at village A.
my lord,
Here is the document because no one from village A
my lord,
had given this Kabilnama. It has been given by a person who looks after or who has the jurisdiction of this village, Malandubi.
my lord.
But the proceeding said that she got married while at the village A.
My lord, I completely agree with lordship. In the written statement, there is a minor contradiction, my lord.
That same thing
But
is in the
does-
written evidence.
My
Also,
lord-
we find out in the evidence,
My lord,
the affidavit in evidence,
my lord.
she has stated the same thing.
She has, my lord, these are drafted by lawyers, my lord. This is a copy
Don't
paste
blame
thing.
lawyers. How the lawyers will know? See,
Copy paste thing.
some clients comes to you.
My lord,
You know, if you are not related to that particular client,
My
how
lord.
will you know everything about that family? Only one what is revealed to the client,
My lord.
by the client to the lawyer,
My lord.
the lawyer has to write.
my lord,
So unless, that is why nobody is blaming the lawyer. It is,
My lord.
it is the duty of the prosecutor to prove.
I agree with the lordship.
Then tell us if
Agree
these
with the
things are
lordship. But-
before the tribunal.
But okay, my lord. But just one, that minor contradiction,
Do you
does
think
it
it's a
completely
minor?
wipe out the authenticity of my document? Where the author of the document is coming and deposing, my lord.
That
And my lord, this is
exactly.
not the only document based
Let
on
us-
which I am trying to
let
prove my
us-
linkage, my lord.
let us-
There is a next of kin certificate also.
Let us assume that this particular Kaji has proved the document.
My
But
lord.
from which village is the petitioner?
My lord, the petitioner was from Chalakura village, then shifted to Molandubi.
She
It's
did not
not,
say-
it's, my lord, there are two villages here. One is Molandubi, one is Chalakura. And precisely has mentioned in the written statement that they have shifted, my lord. So
Rightly,
this
when?
minor contradiction, my lord,
When?
that does not, my lord, doubts this document. And also point two, my lord, this is not the only document based on which I am trying to prove my linkage. There is a next of kin certificate also, and the village is Molandubi. So this is not an alien village, my lord, which I am trying to prove that I was there. It's not an alien village,
That is the reason we are asking you, first thing we have asked you,
my lord.
which year you have shifted to Malanpuri?
My lord, that year
Why
is,
your name did not figure, name of the proceeding father did not figure in between the voter list of 1970 and 1997?
my lord, there is a gap there. But
That is the reason. See, no point of being
My lord-
excited. You have to place the documents to satisfy the case that you belong.
my lord,
to and the
I
address
have
right.
placed documents and I'm not relying only on the Kabinnama, my lord, which is proved by the author, my lord. I'm also relying on the next of kin certificate, and there is no whisper in the order about this.
Hmm.
There is a next of kin certificate also.
Hmm.
Page number 39, my lord,
Hmm.
where it is clearly written, my lord, that the father's name and the daughter name is written there, my lord.
Hmm.
Rahela Bibi, daughter of the person whose name is there in the pre-1971 documents, my lord. This is not the only document, my lord. Now, if you corroborate the entire thing, my lord, does my whatever document I have submitted, does it create a suspicion? My lord, my humble submission is no. Everything corroborates here. There is a death certificate of the father, and based on death certificate only, this next of kin is issued. The author of the death certificate deposed before the learned tribunal. Now here the entire thing is not I am an Indian or not, my lord. Just because I made one minor contradiction, does it make me a non-Indian?
See, it is your case, you have to prove it before the tribunal.
Yes, my lord, absolutely. I agree with your lordship. But there are other documents also on record, which corroborates with those documents, my lord. Now, if the author would not have appeared, then I could have understood. The author is there, my lord. He is saying he is a Qazi in the last 50 years.
Of which village?
My lord, of village B, which is Molandu B, and that's why I am considering, my lord, that
But
is
she
a.
was not there because she said that she got married at village A.
Now, does that completely wipe out the authenticity of my document? When there are other corroborating documents, my lord, in the form of next of kin issued by the deputy commissioner, no question been raised on those documents. From which village? From the same village where she got married.
The time of marriage was mine. So her consent was not taken. That is not there.
But can you raise it? That was very important.
You see the document, that is marriage certificate. She was minor at the relevant time.
My lord,
Whether her consent was taken.
my lord.
My sister is
Kabir
asking
Amma.
a prominent question.
You
Kindly
see.
see.
The cabin number,
The cabin
she was
number.
minor at the relevant time. Whether her consent was taken, that is not there in the,
That point is to be, my lord, seen, my lord. There's as per the Kabilnama, why the Kabilnama has to be rejected on this ground
that is
itself.
why.
Yes, my lord, it is said in 1986. But in all her
1986.
pleadings, she has said she was married in 1996. 96. Categorically,
One
she has
document is
stated.
there, she was born in the year 1971. So
No, but-
1986, she was minor.
That contradiction I wanted to point out, my lord. If your lordship may kindly see the WS in the fourth para, my lord. If your lordship may kindly see, my learned friend is arguing very seriously. But what is the contradiction? I will point out, my lord. Your lordship may kindly see page 23, para 4. That the opposite party got married on 5/3/1996 with Muhammad Ali. This is categorical statement. Same is the statement in evidence, my lord. Your lordship will find in the evidence, my lord, page 54. Page 54, para 4. That I got married on 5/3/1996. And this certificate, the marriage certificate, page 50, what it says,
1983.
she got married on 5/3/1986. This was registered in 2016. Now he is saying, this is, my lord, minor contradiction. These all are manufactured documents. To get some benefit, they are manufacturing these documents and approaching the position. Contradicting himself, 10 years difference.
My lord, this
It's
is
not-
even the learned tribunal is
No,
not,
no.
not making this observation.
This is the,
That is the
this is the
manufactured
record
document.
sheet. This is record sheet.
Where it is written the
It
manufactured
is the
document? No, kindly show me
This is
where it
record
is written.
sheet. Why this?
Where it is written the manufactured document?
This is on 5.
Where it
as
is
per
written is
this
the manufactured
record,
document.
your marriage was 5/3/1986. What is your date of marriage? Tell me.
My lord,
What's
there are,
the current
there
date
are
of marriage?
contradiction, my lord. But is it the finding of the learned tribunal that this is a manufactured document?
No, these are manufactured.
no, is
all
it-
these are manufactured documents.
You can say anything. That's not what the learned tribunal says.
This
You
was
can say this document is not
this is-
admissible.
this is
But
registered
where do you get this
only-
authority to say this is a manufactured document?
2016.
For hearing.
This kind of
You
documents-
merely saying something doesn't
on the
make
basis
something
of this kind of
manufactured.
documents that they are claiming citizenship. Let him say what is his date of marriage. Let him say now what is his date of marriage.
Heard Mr. AWM. Preparing for the petition. And Mr. P. Bachadil and CGC. Respondent number 1. Also heard Mr. M. Politer, Planet Council on behalf of MSP Burwa, Standing Council ECI for respondent number 2. Mr. J. Pine, Standing Council Women Political Department. as well as standing counsel NRC Assam for the respondent numbers 3, 5, and 6. Mr.
5 and
Also heard 3, 5, and 6.
yes.
Also heard Mr. P. Sharma, Editor Support Assam for the respondent number 5. Sorry, respondent number 4. Pursuant to the order dated 12/03/2025, registry has received the relevant reports of case number KFT/D/3012/2012 from the office of the Fairness Tribunal, Pokrajhariti. Place this matter for admission on 10th.
Can it be on Malat some other day? 10th, I may not be available.
7,
7,
8,
8,
8.
8 of April, Miller?
Yes. Peter. Immediately after motion.
Number 9.
9.
Lordship, kindly see the imprint order dated 30/12/2019.
What's your good name, ma'am?
SR Das.
RMS Sardas Learning Council appearing for the petition. And Mr. P. Bachaji learned CGC for the respondent number 1. Also heard Mr. J. Paring, Standing Council, Home and Political Department, as well as Standing Council NRC Assam for the respondent number 2,
4 and 6.
4, and 6. As well as Mr. who is appearing for ECI. M. Colita, Land Council, on behalf of MSP Burwa, Standing Council ECI for the respondent number 3. We have also heard Mr. P. Sharma, Citizenship of Assam for the respondent number 5. In a reference being made by the Superintendent of Police Border Dorong. Now in Fairness Tribunal Court Dorong by its order dated 30/12/2019 in FT Court case number 473/DHL/2015. After hearing the parties and considering the evidences adduced by her, the tribunal opined the petitioner to be a foreigner under the Foreigners Act 1946, who had illegally entered into territory of India within Bekat Assam on or after 25/03/1971. Agreed by the said imprint opinion dated 30/12/2019. The petitioner has filed this writ petition on 26/03/2025 after more than 6 years, 3 months. Call for the records of FT Port case number 473/DHL/2015, decided on 30/12/2019 from the office of the Foreigners Tribunal Court, Dorong, Mongol list on 29th of April.
Obliged.
May it please your lordship.
Just a minute, Mr. Singh.
Copy of the demand that I give. Second.
মুখে কোনো লাগে না। Help yourself.
Page number to printed itu akor কপি কেন কাগজটা ডবল করলাম
এটা কোনো 267
আরেক পেজ number 267 আমার এই জন্য এটা আপনারা মেরিট কনসালটেট করেন আপনার মেরিট কনসালটেশন তো মেরিট না ইউজুয়াল মানে ফ্রম এলিজিবল ডকুমেন্টস পিছন মেরিট কনসালটেশন তার পিছনে
সবরে সন্তান সবরে
না অ্যাপ্লিকেশন যদি করি তাহলে দিতে হবে কিন্তু আমি কিন্তু
শিওর না কম কিন্তু হবো পারো না
হ্যাঁ
হবো পারো
I'm not surprised to be stay order to be properly already applied result document automatic
অ্যাডভার্টাইজ করেছে এই নাম্বার
advertisement to make.
Mr. Sekia and Mr. Bhachaji, we have a set of rules in the High Court. One, Mr. MS Kalra is appearing on behalf of the respondent. Now, he has sought for a VC permission yesterday night by email. It was sent at 9:10 p.m. yesterday night. The rule says the video conferencing link shall be shared only to an advocate who is a member of the Bar Council of Assam, Nagaland, Mizoram, and Arunachal Pradesh, as well as registered with the Guwahati High Court Bar Association and / Guwahati High Court Advocates Association. The learned advocate shall request for video conferencing through email to the official email ID of the concerned honorable court, where the case is listed with a copy of the said email to the official email ID of the registered judicial at Guwahati High Court conferencing such and such, at least 2 days prior to the date of listing of the cases during office hours by mentioning the details as mentioned below. Now, this email from the concerned lawyer, Mr. MS Kalra, raised by the registry only at 10:09 p.m. yesterday. So, if we permit in violation of this rule. So,
Can I explain if my lords would permit? Can I explain?
and we cannot help you because this is the rule we have and this is a full court decision, I can tell you.
Lordship, my submission will be very clear. There is no caveat. So they have no right to appear at this. If Lordship dismiss it or without issuing notice, nothing is going to happen. So
No, I'm
Lordship,
sorry, there is a caveat. And my lords, there was no clarity with respect to where this matter is being listed because it was listed before the Honorable Chief Justice. One of the Honorable Judges recused there. And then the matter, the date was fixed. So therefore, we weren't aware that which court should we send the request to. That is point number one, my lords. Secondly, my lords, it is a genuine difficulty that I am unable to attend physically. I practiced before the Honorable Apex Court. I couldn't make it because of some matters being listed here. Therefore, we requested last month when we got to know that we are unable to make it. Therefore, as an exception, my lords, of course, we have a caveat number. Number two, my lords, our wakalatnama is on record. Therefore, to meet the ends of justice, my lords, if my lords would just permit us to assist, that's all. There is nothing more than that, my lords. And I understand that it was sent last evening, my lords. But we were also under a genuine difficulty because of the the matter being listed before a different bench, and then the Honorable Chief Justice directing the matter to be listed today. But we weren't aware that which court should we send the request to. That is the only genuine difficulty we had.
Send it to any court. You are supposed to send it to the registered judicial.
Indeed, Maloj, we had then sent it to the Registrar Judicial only. And we are only here to assist, Maloj. That's the only short point request we have from our side, Maloj, because this issue, I had the opportunity of assisting the Honorable Supreme Court with this issue, which is there before my lords. Therefore, if my lords would only permit, we want to provide our assistance, Maloj. Nothing more than that.
Lordship, there is no formal caveat. The cause list also, it is not
It
reflected.
is not there.
It is not there. So Lordship would be pleased to.
Maloj, the caveat number is on board. I can show the caveat, and Vakalatnama is also mentioned, Mr. Sir. I'm sorry. The caveat was filed on Maloj 27th of March. We have the caveat number with my colleague will tender it in court, Maloj. I have the caveat number with me, and my local counsel's Vakalatnama is on record also. Mr. Saddam Hussain, it is evident from the cause list. Mr. Saddam Hussain is my counsel, Maloj, whose Vakalatnama is on record. And the caveat number, Mr. Saddam Hussain will just tender. We have the filing proof of the caveat. Mr. Saddam Hussain is in court, Maloj, and he can tender the caveat filing proof.
Okay, Mr. Saddam Hussain will assist for the respondent, nothing else. We cannot extend it to you at this moment, this basic. Yes, Sharma.
Maloj, there was a genuine difficulty, Maloj. I kindly appreciate that the matter came up before a different bench.
We cannot bypass that particular notification. Sorry.
Maloj, I understand, but at the same time, Maloj, if the request has not been made by him,
you can connect and here you will not able to make any submission at this stage.
Plus, at least that opportunity may not.
You can hear because it is online. That's all. Dealing Kora. Yes, Mr. Shekya.
Lordship, we are on a very narrow campus. Rather, it is not adversarial litigation. My only submission is that an advertisement was issued in the month of December last year for filling up of around 5,000 upper primary and lower primary school teachers. Advertisement was issued, and they certain candidates who actually had 18 months DLED courses. In fact, from 1920 onwards, state government was always allowing 18 months DLED holders to participate and considered them to be eligible for recruitment to the post of assistant teachers in these schools, Lordship. However, due to change of law by the Honorable Supreme Court, now the DLED 18 months was not considered till few days ago. Now again there is a change.
Right.
Whatever may be the case, we have to follow the final verdict of the Honorable Supreme Court. Honorable Supreme Court last year said that it is not valid. Now it is again saying that it is valid. What we are concerned now is that Lordship will kindly come to page 267. There is a notice. And in fact, all the writ petitioners who filed the cases, Lordship, they could not get any interim order before this notice was issued on 18-3. 18-3's notice, if Lordship is... May I please this notice, Lordship? Page 267.
276.
267.
266.
No, that 95.
95, 8 or 267.
Yes.
268 at the top. So they did not get any interim order prior to the issuance of this notice. This notice was issued. It is for information of all concerned that physical documents verification of the candidates who have successfully submitted their online application and upload the relevant documents in support of their candidature against advertisement by number 26/12/2023 for recruitment to the post of regular teachers in LP and upper primary schools under DEE Assam. Date 28 March to 11th April. then the place is there. Now, in this regard, it is to inform that first phase of the physical documents verification will be starting from 28th March to 29th March, and the second phase of the physical verification will start from 1st April to 11th April, and the list of candidates for the second phase verification will be published in due course. So they have filed an IA to challenge this. The recruitment process was going on, and this particular part, that physical documents verification, is for the purpose of assessing the candidatures credentials. We are not preparing the final merit list, nothing. So 2 phases were given, and they have challenged it, the Honorable Court, on that is the impugned order. That is the only fact which is relevant for the purpose. Page 110. A order was passed on 21st March. The first phase started on 28th, 20. I'm coming to the second paragraph. These 2 interlocutory applications has been filed praying for stay of the process of document verification, which the respondent authorities have initiated by notice dated 18/3/2025, whereby the verification of documents of the candidates pursuant to the advertisement dated 26/12/2023 for filling up of post of assistant teachers in lower primary and upper primary schools in the state would be taken up in 2 phases. The first phase of verification started on 28th March to 29th March. Thereafter, the verification of documents for the second phase will start from 1st April to 11th April. The names of the candidates would be published and notified in due course. Issue notice so-and-so, heard so-and-so. Now, paragraph 6. After hearing the learned counsels for the applicant and considering the connected writ petitions are fixed for final determination on 8th April, that is coming Tuesday. And also considering that the verification of documents of the applicants would be taken up in 2 phases, that is first phase of verification starting from 28th March to 29th March, and thereafter the verification of documents for second phase will start from 1st April to 11th April, for which the list of candidates would be published in due course. The interlocutory applications be listed along with the writ petition on 8/7. Then finally, the Honorable Court passed another order. In the event the connecting writ petitions are not taken up on the next date fixed, appropriate orders for the interlocutory application shall be considered on next date fixed. However, considering the second phase is yet to be started and no names of the candidates have been published till the next date, that is 8/4/2025, the verification of the second phase may not be taken up. This part is what is troubling us. We do not want to waste 1 week time, Lordship. That is the reason why we have filed this, and this matter came up about last Friday because one of the honorable judge was not, he deemed it not proper for him to take up the matter, so he recused. So that is why the matter is before this honorable court. What I am praying, Lordship, because if the Supreme Court final order is in their favor that 18 years DLED course makes them eligible to apply, they have already applied. Their cases will also be covered because this verification of documents will not give the final status for us to give the appointment. It has a long way to go. So in the meantime, the process should not get stopped.
Now, just Mr. Saikel, just for clarification of us,
Lordship.
when the advertisement is issued, this 18 months DLA was not under consideration.
It was
And
not.
the candidates who did not, whether these candidates who had only 18 months delay.
They have applied.
They have applied.
They have all applied.
Their application has been accepted.
Yes, we have accepted. We have to verify their documents also. We are verifying documents of all the applicants, not we are singling out anybody. Who have 18 months, who have 2 years, also we have to find it out from the
It is
applications.
not a grievance of these
We are-
applicants here that they are.
We are not leaving aside anybody. Nobody is shortlisted. We are verifying,
the
then we'll know. They should not have any objection.
What is your objection if this verification process, second phase of verification goes on?
My lord, with my due
Yes, yes, let me
permission
senior
from my
counsel
learned
sub-
senior friend, my lord, the only contention we were raising at that point of time when we moved the IA for staying the process was because, my lord, in this particular notification, there are 4,100 candidates who are called, and all the 4,100 candidates are for 2 years diploma holder. There is
Right.
not even a single candidate for 18 months.
Right.
So our anticipation grew that 4,100.
Now, when the advocate general is
Yes,
saying,
man, of course, I humbly appreciate what my learned senior friend is saying. So we anticipated that if 4,100 seats are occupied, 5,000, my lord, the vacancies are there, and we petitioners are around 1,700. There are list of cases, my lord, the
at the
analogous.
time of filing of the IA,
Yes,
you
ma'am.
had in your assumption that since these are the candidates having only 2 years of DLA
Yes, my lord.
considered, and you have been left out.
Yes, my lord.
Now,
Yes.
the advocate general is stating before the court
Yes, my
that
lord.
even the candidates having DLA of 18 months will be considered because that is the direction of the Honorable Apex Court.
Yes, my lord, of course.
Any hindrance in that?
No, my lord, no. We will have.
Yes, Mr. Bhattacharya, if you are comfortable by sitting.
No, my lord, difficulty is that I'm grateful to my Advocate General. Difficulty is that, my lord, apprehension, because 4,000 did not include a single petition. If what Advocate
My
General is saying,
submission is very clear.
if Advocate General, if it is, that is recorded,
Will be
what
recorded.
he said, it is recorded and he is agreeable to that through his argument.
No.
Then it is
This is the stage of documents verification. Now, if during the stage of the second phase of document verification for these posts, those candidates who have applied having 18 months DLA are also to be considered. There is, I didn't think there has to be any objection in that part.
May I make it?
Yes, please.
Let my apprehension be recorded,
Yes.
and in response to that, let
See,
his
maybe you are in that having 18 months DLA, maybe 1,700, and 2 years DLA, maybe 2,000 or 4,500.
Yes,
It exceeds 5,000 posts.
Yes,
As what I, that is, see, there may be an applicant 7,500, 8,500, but out of that, only on the basis of their credentials, they will be secured.
Yes, my lord.
Out of those posts, only those amount will be those candidates, there has been number of posts advertised, only those candidates will get it. Here is question of 2 years DLA or 18 months DLA will not be there.
no, that is not coming up again.
Exactly.
Actually, my lord, if that apprehension is absolutely removed,
Yes.
we have no problem.
The
The
submission.
apprehension,
Absolutely, Lordship. My submission, Lordship, may kindly record
Yes, absolutely.
that all what we are doing, we are verifying. It is not only the 18 months. There are a lot of candidates who do not have the 50% mark, may not have 40 mark. These are all being verified now.
So with regard to the eligibility criteria.
We are verifying all.
You are verifying.
We are verifying all. And whatever outcome is there on 8, we'll follow that.
Mr. Mazumdar, just tell us which is the page having the advertisement, initial advertisement.
Initial advertisement has not been annexed here because we have only given the IA part.
You have the initial advertisement.
Not on this record.
But reference is there in the
Reference is
18th.
Because we want to know the eligibility, because definitely at the time of that advertisement, the eligibility of 18 months was not there for.
Yes, my lord. That is the writ petition, my lord, which we have filed. That is writ petition 477. There we have said, my lord, the impugned notification, which was published subsequently on, my lord, 2nd of January 2020.
After the judgment of the Honorable Apex Court.
After the first judgment of the Honorable Apex Court, wherein our validity was decent title. We were removed. Then we came before this court. This court, my lord, by the, my lord, very faithfulness of the Honorable Division Bench, we were protected by an order of this Division Bench saying that you all will be allowed to participate, irrespective whether you have 18 months or 2 years. And our results will be kept in steel cover. Now, my lord, in between, some candidates moved to the Honorable Supreme Court. They filed a review, reviewing the original Supreme Court order. Here, my lord, in the review order, in Javir Singh's case, Supreme Court said that you all are at par. 18 months and 2 years are at par. And basically, they recognize our degree. So we moved before this court for implementing that order, my lord. Then, my lord, this certain anticipation came before these petitioners that they are calling only 2 years candidate. Why they have left us? Because we are at par with the other candidates. My lord.
So, now we have heard Mr. General have excused all the candidates or including the candidates who have applied 18 months DLA. I don't think so there is any.
No, it will not be
only
only
thing-
agreement.
it is very expressive so that both the arguments can be.
My lord, we have prepared a list of dates for your lordship convenience, just for a background, if your lordship would like to just have a look, my lord.
চব কৰিব লাগিব। ইহঁতে আমাৰ মানুহৰ কৰিব নোৱাৰে। চাব লাগিব কাৰ আছে দুটাকে দিব তোমালোকৰ বস্তুটো মাইণ্ডত ক্লিয়াৰ অকল মানুহ যদি মাৰ্কছ বেছি আছে পিছত কেনেকে ধৰিব চব 50% লাগে নহয় অকল চব চাব লাগিব চাই পেলাই গম পাব লেট কৰিব দুটা স্কুট যদি এইটো 15 মাৰ্কছ কোৱালিফাই কৰে তেতিয়া ৰুমত সোমাই গ'ল তেতিয়া তাহাঁতৰ বাকী মাৰ্কছ দেখব তাহাঁতি যে প্ৰথম দুবছৰৰ পিছৰবিলাক কেনেকে চাব চবৰ মাৰ্কছ চাব তেনেকে নহয় নহয় ওপৰত মই চেষ্টা প্ৰথম 4,000 Lord. Yes, we will not give it. So far as we are concerned, also, if today, because what we are asking, because our rule also says, that's why on 8 we'll argue. On 8 we'll argue. But verification, only verification, whether which will, because Lordship is not deciding that aspect now. That aspect will be coming to the learned single there. And what is the Honorable Supreme Court judgment? Every line we'll have to read and interpret. That will be a different issue.
My lord, may I just add to
Because it will not to their detriment at this stage.
My lord, may I just add to what my learned, my senior counsel has submitted? My lord, on the last occasion before the learned single judge, the same point also raised, whether it was further recognized by any authority. My lord, the apex body is NCT. NCT, in pursuant to the order of Honorable Supreme Court, they have accepted this validity. And yes, my lord, altogether, correct, my lord.
On 8, all these points will hit.
On 8, my lord, correct. Yes, my lord. Yes, ma'am.
It's all right.
Along with all other applicants. All other applicants.
Absolutely, ma'am. We have no objection.
Applicants. Who have applied? We are going to put that no point. One question. All issue number. Documents verification, caste certificate, all that. Not only at the part. It did not. Yes, it will not. The caste certificates, that reservation or the marks নাই জানো 50 marks নাই জানো 50 marks 45% নাই জানো এইবিলাক চাব নালাগিব ডকুমেন্টছ সেইবিলাক সেইবিলাক ক'ৰবাত ভেৰিফাই কৰিব পাৰে তুমি যদি নোচোৱা তুমি কেনেকে জানিবা ৰমা নে ৰমা you have to see almost something এই সব মাইলে Department of School Education. Yes, Department of School Education. Secondary to people, Department of School Education, elementary, secondary, college.
My lord.
Please order to petition.
My lord, may refer my lord, the short chronology of list of dates I've given. There I have detailed mention, my lord, at page number 6, at point number 22 is the advertisement for filling up of 5,500 posts of LP and UP school. Total, they have given, my lord, 5,500 posts, and out of which, if I may, 8,800. Item number 22, my lord, at page number 6. My lord, 3,800 for LP schools, my lord, and 1,750 for upper primary schools, my lord. If you're okay.
Detention of Lago. Upper primary.
Forty-four, my lord. At page number 169 is the order, my lord, of the appeal memo. 44 of 2000. Yes, my lord. At page 169 is the operative part, my lord, of the appeal memo. It is 3rd of May 2024, where the division bench disposed the appeal. Yes, my lord. 836 is the My lord, can I just?
Yes. Yes. It's all right, my lord.
Connected.
So we'll verify
Represent
all
equal
the applicants.
connected
Yes.
petition to then able to
Yes.
consider for
All the applicants or all the respondents, lordship has used the word. Yes. Yes. Yes, absolutely. We will do
There
for
are
everyone.
more than quite a good number of writ petitions are there. So
There are around 11 or 12 writ petitions which are pending on 8th to be heard. So only
We'll do it en masse. En masse. All the applicants. All the applicants. Within bracket, lordship may also including the 18 months DLed holders also. That will clarify everything. Everything. We will do it. In the after the case, we may. Itu kami argumen. Betul tak? Ini yang satu ini oleh itu. Okay.
whether your lordship would like to specify the dates before?
The date is given.
By
before 11th April.
before 11th April.
Yes, yes.
In the second phase.
In the second phase. Second phase, if two. Third phase. Lots.
Obliged, my lord.
Deeply obliged.
Obliged, my lord.
Highly obliged.
May it please the Lordship. Lordship, the present petition has been filed challenging the judgment passed by the learned foreigners tribunal, my lord. Lordship, in the impugned judgment, it has been observed that it has been held that I am a foreigner and and I have migrated and reason which Lordship, the present petition has been filed. And Lordship, the observation that it was held was reason of such observation that I have not produced any kind of a evidence which depicts that I have born before the year 1971. And also, I have not produced any kind of a evidence which shows that I have any kind of a linkage with with my father, Lordship. Subsequently, Lordship, this present petition has been filed, Lordship. Yes, my lord. If your Lordship may look upon Annexure 1 at page number 16, my lord. Lordship, I was born in the year 1970. Yes. Yes, my lord. My lord, in this matter, Lordship, I was born in the year 1970, and Lordship, I have annexed various documents, such as if your Lordship may look upon Annexure 1 at page number 16. Lordship, page number 16. 1/6, my lord. Lordship, this is the certificate which was issued by my school, in the school which I was studying. Lordship, if your Lordship may, if your Lordship is there, herein the certificate, it is the declaration which has been made is Shri Rukia Begum, daughter of Rahiz Uddin Mullah, village so and so. She completed her studies in the school on 31st December 1979. She passed out with B grade in a 4th standard in her last examination, and she was born in the year 1970 on 1st January 1970. As per the admission register, her age is 10 years. Her character was fine during the school period. Lordship, her studies in the year 1979. This date has been, there's a typographical error with the date which has been mentioned by the school. It was supposed to be Lordship 1997. Yes, Lordship, and the same Lordship 1997, Lordship, the same has been stated in my petition at paragraph number 3, my lord. Lordship, it has been issued by the school. Apology, my lord. Authentication. Lordship, this has been issued by the school itself. Yes, Lordship, there are various other documents as well. Lordship, the same has not been considered by the tribunal, this certificate. Lordship, the headmaster has issued this document. However, the headmaster of the school has issued this document. However, Lordship, the Honorable Tribunal has held that this document is unauthenticated one. Yes, ma'am. Yes, ma'am. Yes, my lord. Yes, my lord. There are various other documents. Yes. Yes. Yes, my lord. Hmm. Lordship, there has been a typographical error. It is supposed to be the passing year should have been 1997. It has been mistakenly mentioned as 1979. Yes, Lordship. Apology, Lordship. It is 1979 itself, Lordship. It has been mentioned. And apart from that, Lordship, um, no, my lord, it has not. Never been proved, my lord. And my father's name, my lord, and my father's name as well. Yes, my lord. No. Yes, my lord. It has not. Lordship, the second document is at page number 18, is the PAN card, which has been issued by the government itself, Government of India. Lordship, in the PAN card also. Yes, Lordship. No, my lord, she is not working, but Lordship, she has applied for this PAN card document in order for that purpose as well. The same has also not been considered by the tribunal. Lordship, we have annexed these documents with our written submission. Yes, ma'am. Yes, ma'am. Yes, ma'am. Apart from. No, my lord. Yes, yes, ma'am. My lord, the land revenue receipts are also been. Lordship, it has been annexed at annexure 3, page number 19, my lord. Revenue receipts, which has been paid by my father and my grandfather. Lordship, the observation. Lord. Lordship, it was Tauji land. Yes. No. Lordship, but there are lordship records. Lordship, there are voter list as well of my name reflecting my father, a certified copy of the vote. Lordship, it is there is a certificate which was issued by the Gao Panchayat at page number 31, my lord. Lordship, all these documents was enclosed with the written submission. However, none of it has been examined by the learned tribunal, my lord. And apart from that, there was a sworn. Apart from that, my lord, there are various sworn affidavits of my brother, my husband, two of my brothers, my husband, and one of my uncle. The same has also not been cross-examined and has also not been considered by the learned tribunal, my lord. The entire proceeding before the learned tribunal. No, my lord. Lord. Yes, ma'am. Yes. Yes. Lo- uh, Lordship, since Lordship, based on the Gao Panchayat certificate, based on the evidences and yes, no, my lord, it has not been proved. Lordship, apart from that, I have been married to. Yes. If your lordship may just grant me some time to assess the honorable court, lordship. Well, lordship, there are various documents which are been unexplained. Yes, ma'am. Yes, ma'am. Yes, ma'am. Your lordship may just grant me some time. I'll assess the. I'll be better be able to assess the honorable court in regard to that, my lord. Apology, my lord. Deeply obliged.
Lordship, in this case, Lordship, some police report has been sought, Lordship, on earlier occasion, Lordship. So, Lordship, grant me some time, Lordship. It was not yet received, Lordship. Immediately after vacation, Lordship. 23rd or 24th, Lordship.
Lordship, can it be taken up of 23rd, Lordship? It's not inconvenient. Yes, my senior.
Safely.
Yes, fine. I'm sorry.
Made to your office. This matter has today come up for consideration of bill payer, Lordship, NCR received. So, problem.
May I please, your lordship? Lordship. Today speaks for consideration of bail, lordship, and LCR has been received. Okay. Sorry, my lord, I am there. Lord, this petitioner is in detention camp. Earlier, he was declared as Indian. But subsequently, one proceeding has been dropped, an expert order has been passed. The petitioner did not receive any notice. My lord, annexer 1. Yes, and annexer on page 19, my lord. My lord, expert order. How far is the annexer 1, page 19? 19. Application number 103/07. Hello. Lordship, maybe the matter may be taken in the next one. My senior legs in another court. Maybe.
May I plead the Lordship? I beg to mention for listing your Lordship. BA number 1031 2025. It's not listed, your Lordship. Yes, Lordship. 29. It's an urgent matter, your Lordship. Tomorrow. Okay. Obliged, your Lordship.
May it please your Lordship. Lordship, I beg to mention two bail applications for listing your Lordship for motion. Your Lordship. Lordship on 28/3/25. Yes, your Lord. Deeply obliged.
May it please your Lordship, I beg to mention for listing of the bail application. Today, Lordship, I have filing number. Lordship, can it be tomorrow? Matter arising out of same FIR is listed tomorrow. Yes, Lordship. Obliged, Lordship.
My application, Lordship. Another regular bail application, my lord. Considered case trial is going on, my lord. Now, patient says evidence status, my lord. This is second time bail application, my lord. Ground is that, my lord, long detention, my lord. That is 2 years, 5 months is completed, my lord, behind the bar, my lord. My lord, kindly call for the extent with the LCR, my lord. I have mentioned. No, my lord. No. My lord, already. Answer. Thank you. Thank you. Obligement.
May I please your Lordship? An application under section 483 of BNSS. The petitioners who were surrendered 4/3/2025 before the CGM Nagaon. As per the order passed by this Honorable High Court, they have already filed an anticipated bail application before this Honorable High Court, and this Honorable High Court directed them to file an regular bail application before this CGM. But the Chief Judicial Magistrate Naga have not considered the same and arrested them, sent them judicial custody. They are behind the bar 30 days. Can you see the page number 37?
This PH bill rejected on the basis that previous, they have already taken 2012 and another anticipatory bail, but they have not compliance on condition imposed by this Honorable High Court. Non-compliance of the anticipatory bail orders, this anticipatory was bill rejected.
My lord. My lord, no comment. Charge case, sir.
CGM no. No, not.
Please.
Not point. Yes.
Already filed. Commit return will say. Return को तो मैं वैसे नहीं था नहीं confirm no confirm आपको एक तो देखो
May 11.
Please, Lordship. My lord, matter may be taken after 1 and 2. Action. Lordship, before vacation, any day. Any did picture will. Lordship. Oblige.
Yeah, please, Your Lordship. So this instant petition is for passing the complaint case pending for the Planet Court of CGM Ozai. The respondent's filed complaint petition, Lordship, is page number 14. And the present petitioner number 1 is the mother-in-law of the petitioner, and 2 and 3 the LIC agent, and 4 is the sister-in-law of the respondent, Lordship. The main case is, Lordship, the respondent's wife died in an accident. He made an accident claim, and thereafter they have opened a joint account with the petitioner number 1. Lordship. Thereafter, the amount was transferred into the joint account of the petitioner and the respondent number. Petitioner number 1 and the respondent, Lordship. Thereafter, respondent have withdrawn that amount. Lordship. That is why he has made this complaint petition before this learned court that he has misappropriated the amount. Lordship. In fact, he is also implicating these 2 petitioners, Lordship, who are the LIC agent and a club member of LIC agent. In collusion with them, she has done this. It is his allegation, Lordship. In fact, Lordship, petitioner number 1 being the mother of the deceased, she has 2 other policies wherein he was nominated as a nominee. So the respondent had opened a joint account, Lordship, so that he can get the share of that amount, Lordship. But as of those amount has not been, the amount has not been transferred into the account. Only the first death claim benefit has been transferred to the account. He has withdrawn that amount, Lordship. So upon vengeance, Lordship, he has filed this case in fact also. Lordship. Photo margin. On that date, Lordship, we have taken adjournment, Lordship. Lordship, Lordship.
May I please, Lordship? Lordship, a Bolero pickup registration number AS 12CC 1072, which was seized by Rota PS. Lordship, the petitioner is the owner of the vehicle. And the Lordship, the driver and the helper uses to transport the various goods from one place to another place. The petitioner is not aware that they have transported suspected cannabis in her vehicle. Lordship, kindly see page 5, para 9. Lordship, the petitioner have been paying installment of the said vehicle of rupees 20,640 per month. There's copy of the loan repayment schedule issued by Solomondalam Investment and Finance Company. And the Lordship, the vehicle of the petitioner is laying in the police station without any coherent care. In such situation, day by day, the vehicle will be damaged, Lordship.
My lord. My lord. My lord, I owe my lord. Required or not. My lord. My lord, Udalguri, my lord.
Rota PS.
My lord. 11th, my lord. My lord, it is not. My lord. My lord. My lord. My lord. My lord. My lord. Tenth, my lord. My lord.
Declaration.
My lord. Copy of the-
Lordship, this is an anticipatory bail application under section 482. FIR is on page number 8. Lordship, my clients are mere grocery store employees with no criminal history, yet they have been falsely implicated. Lordship has earlier granted bail to the all prime accused who have been arrested in this case. I most humbly pray that they may also be granted interim protection, Lordship.
Lordship may first, my lord, kindly please the cost title, my lord. Page 1, my lord. My lord, here 1090 is also added, my lord. Here, although in the FR not in the section 109, my lord. Page 1, my lord. Yes, sir, I am also confusing how it is in one. My lord, 109, not here. Lordship may call for CD at this stage, my lord.
Should some interim protection.
It is in the Kali Mandir, my lord. My lord. It was on 11/3 co-accused. Lordship, lordship. Okay. My lord. My lord. My lord. After some.
May I please lordship, my lord? This is NDPS commercial matter, my lord. We're praying for bail on only two grounds primarily, my lord. First is that the grounds of arrest were not furnished to the accused petitioners, my lord. In that regard, we filed an additional affidavit, my lord, that may be on record, my lord. And the second is prolonged detention, my lord. We are behind the bar for 1 year, 10 months, and 8 days, my lord. Out of the 7 PWs, my lord, possibly only 3 have been examined, my lord. As per my instructions, my lord. We've annexed lordship's order as well, my lord. That is page 76 of the affidavit, my lord. Lordship referred to a 1976 judgment, my lord, that I could not get a printout, my lord. Contraband was, my lord, 10.124 kilogram of opium, my lord. I believe it.
No.
Now, you can look at page 73 once, of the affidavit. We have annexed 7 orders, we've also shown the sections, The Malad allows me to get 2 new judgments, Oh.
Okay.
these are not the grounds of arrest, my lord, the Kobe testimony. This will possibly not be enough, my lord, as per Kobe testimony. Well, that is a page, para 49 of Kobe testimony. May I place the judgment, my lord? May I place the judgment, my lord? This was the, my lord, 15th of May 2024, my lord. May. Actually, only quoted this judgment, my lord. I will only take my lord to para 49, my lord.
Para 49.
48, my lord, beg my lord's pardon, my lord. Para 48, my lord. May I read, my lord? It may be reiterated at the cost of repetition that there is a significant difference in the phrase reasons of arrest and grounds of arrest. The reasons of arrest as indicated in the arrest memo are purely formal parameters to prevent the accused from committing any further offense for proper investigation of the offense, to prevent the accused from causing the evidence of the offense to disappear, tampering in with such evidence in any manner, to prevent the arrested accused from making any inducement, threat, or promise to any person acquainted with the facts of the case, so as to dissuade him from disclosing such facts to the court or to the investigating officer. These reasons would commonly apply to any person arrested on the charge of a crime, whereas the grounds of arrest would be required to contain all such necessary details in hand of the investigating officer, which necessitated the arrest of the accused. Simultaneously, the grounds of arrest informed in writing must convey to the arrested accused all basic facts on which he has been arrested, so as to provide him with an opportunity for defending himself against custodial remand and to seek bail. Thus, the grounds of arrest will invariably be personal to the accused and cannot be equated with the reasons of arrest, which are general in nature. In my humble submission, my lord, possibly even the reasons of arrest are missing, my lord. And there's another one, my lord. May I place it, relatively new, my lord. There are two actually, my lord. May I place both of them? No, one is Subhash Sharma, my lord. That is 2025, my lord. But you can come a para 8, my lord. This was not relating to 22-1, my lord. This was relating to 22-2, my lord, the Constitution of India, my lord. Para 8, my lord. Once a court, while dealing with the bill application, finds that the fundamental rights of the accused under Articles 21 and 22 of the Constitution of India have been violated while arresting the accused or after arresting him, it is a duty of the court dealing with the bill application to release the accused on bail. The reason is that the arrest in such cases stands vitiated. It is a duty of every court to uphold the fundamental rights guaranteed under Article 22 and 21 and 22 of the Constitution, my lord. And then, my lord, why the arrest memo would not be grounds of arrest, my lord? This is Ashish Kakkar, my lord. There are no paragraph numbers here, my lord. Can you turn to page 2 of the judgment, my lord? It would be serially, my lord, third para, my lord.
Can you read?
Upon perusing annexure P3, we can see that what has been provided to the appellant is only an arrest memo in the prescribed format, which is meant to be given to the appellant by way of intimation. It has been filled up with the name of the appellant along with the place of arrest. Additionally, it has been written that he has been arrested based upon the statement of a co-accused. So these all would not be grounds of arrest, my lord.
But in this particular
This particular name,
actions and everything has been provided.
circumstances, place of
That means
arrest,
You have been arrested.
date and
The
time
grounds
of
of arrest
arrest.
are not there, my lord.
Those grounds of arrest will come under the provision sections is there.
That would also not be enough, my lord. May I take my lords to para page, my lord. Page, my lord. Page 97, the order starts, my lord, or the affidavit, my lord. We kindly come to my lord. Paragraph 19. Page 106, my lord. paragraph 19, my lord, of the, in the affidavit. my lord. Reverting to the case in hand, the arrest memo of the petitioners reflects that the column like name, particulars of the person arrested, concern PS, place of arrest, date and time of arrest.
19 you are reading, right?
Page 106, para 19, my lord. What should be seen, my lord? Time of arrest, injuries present at the time of arrest, signature and name of relative of the person arrested, signature of the arrested person, the signature, full name of the arresting officer. There is no indication in the arrest memo regarding ground of arrest showing a different column.
But here the sections are provided.
Sections are provided.
Sections are always provided. my lord. So that would not
Circumstances,
be enough.
date
The
and
grounds
time
of
of
arrest.
In
arrest.
the paragraph, there is no mention that sections have been provided. Paragraph 19, which you are telling us.
Yes, my lord, honorable in public broadcaster, my lord. The reasons of arrest are the, my lord, earlier it was 41 1A, those grounds, my lord, before warrant when they can arrest, my lord, without warrant, my lord. Even those are missing, my lord, the reasons of arrest, my lord. The grounds of arrest would be particular, my lord. May I take my lords to the,
Only that column, Lord.
may I take my lords to the page 16, our forwarding report, my lord. These would be the grounds of arrest, my lord. And my lord, prolonged incarceration, my lord. May I place them, my lord?
Mr. N. Mahajan, learned counsel appearing for the petitioner. And MS S. Das, right?
And
And learned additional public prosecutor for the state.
Hello, may I
Yes, please.
seek only one indulgence, my lord? Page 143 of the affidavit, my lord. Another order of this honorable court, my lord. Para 22, my lord. Page 143. Para 22, my lord. Please see, my lord.
Yeah.
Para 20, may I read, my lord? A perusal of the aforesaid notice reveals that the only information provided therein was the case number of the police station in which the arrest was made, that is Mongolda PS case so and so, along with the relevant penal provisions, namely sections so and so of the BNS. No further details were furnished to the petitioner in the notice issued under section 47 of the BNS, which was served upon him following his arrest. Providing the mere sections would not be grounds of arrest. Prolonged incarceration, may I please, your lordship allows me.
Ten point 124 cases of opium
Yes, ma'am. 10.124 kilogram of opium.
recovered from the position of the petitioner. And according to they were arrested on 23/05/2023 in Delhi Police Station, case number 42 of the 2023 under section 18 within bracket 3 of the 29 of the NDPS Act. Earlier bill were rejected, right?
No, Mala, this is the first application. One more indulgence. Lordship allows me, Mala. Page 81, Lordship's order, Mala. Lordship referred to our division bench judgment, Mala. Ajit Kumar Sharma, Mala. 1976, I no one knew, Mala. It has been enshrined in by our High Court since 1976, Mala, section 50.
During the deliberation of the matter, Mr. N. Mahajan, counsel appearing for the petition, committed that while arresting the petitioner, police did not furnish them, furnish of the communicated
Has to be written.
the grounds of their arrest as required under section 50 and 50A of the same and their family members. Under section 50 and 50A of the CRPC. Equivalent to 57, right? Oblique 48 of the BNSS 20. In this regard, Mr. Mahajan, Learned Counsel relied on the decision of the Honorable Supreme Court in the case of Probir Purokayasta versus State in bracket and City of Delhi, reported in 2024 SCC 254 123 Roman Directorate of Enforcement versus Subhash Sharma SUBHASH Sharma reported in 2025 see online SC 240.
May I also please Vihan Kumar Malik? Because 37 is here, Malik. Vihan Kumar says because 37 do not here bar.
Not required to have it.
Lordship has it, yes. Vihan Kumar, that is at Para Malik. 21 Malik.
Vihan Kumar versus State of Haryana and another reported in 2025 SCC online SC 260. 2025 to bracket. On that effect. Assis Kakkar versus UT of Chandigarh. Criminal appeal number 1518/2025. Decided by the Honorable Apex Court on 25/06/20. And the other decision of this court, annexed in the additional affidavit. Filed by the petitioners in this case on 01/04/2022. The respondent state shall file its affidavit in the matter on or before tenth of April. Clarifying whether the provision of section 50 and 50A of this complied with or not while arresting both the petitioner on 23/04/05/2023 in Delhi PS case number 42/2023. has been provided by the Honorable Supreme Court Delegate. Copy provided in behalf. Director of Enforcement. Bottom up. Run for Kumar Professor. Yeah. List accordingly on 10-0420. Copy of it. File your affidavit. Will consider.
Obliged, my lord. Highly obliged.
Be very specific in your affidavit whether you complied with or not. That's not.
Obliged, my lord.
And in this case, my lord, I have filed additional affidavit today, taking the plea of this arrest procedure. And may I submit this? This is not on
File your additional affidavit.
today filed, my lord, but not on record, I think.
Mr. H.R. Chaudhary, learned counsel appearing for the petitioner. Submitted that that an additional affidavit has been filed today on behalf of the petitioner. Stating that on (28) 10/2023, while the petitioner was arrested in Patarpur Police Station, case number 294/2023, under section 21 C of the 25/29 the NDPS Act. He was not communicated with the grounds of arrest as required under section 50 of the Sheriff as well as family member was not informed in terms of the provision of section 50A of the Act. So the affidavit is not incorporated and it's not available in this case. We have to place this here on 7
My lord, it may be on 9th, my lord.
on 9. Incorporating the same additional affidavit to the petitioner filed to the request.
In this case also, my lord, taking the same plea, additional affidavit, I will file tomorrow, my lord. Already it is on record, so.
List on 9.
Obliged.
Mr. H.R. Chaudhary. Yes, Mr. Bora.
My lord. Once I have filed the additional affidavit, my lord, page 32, let them file the reply, my lord.
When?
28. 28, my lord, 28-3, my lord.
It's not before us.
It was on record, my lord.
Simply wait.
Page 32, my lord.
Mr. M. Bora, Council, Senior Council.
Copy it, my lord.
They submit counsel for the petition and I must end up.
Did you have received log?
By filing an additional affidavit on 29/03/2002. It is stated that on 15/01/2025, and the petitioner was arrested in Boko Police Station case number 23 of 2025 under section 22 within bracket C of the NDPS. The state did not comply with the provision of section 47 of the PNSS. Inform me the grounds of the instant Boko case. How to did not inform his family member in terms of section 48.
11
আগত জেনে কি
ঠিক আছে
list on syntax.
My, not 10th, my lord.
Okay.
Well, in this case, we are filing an additional affidavit and they have also replied.
My lord, as per order, honorable court, my lord, we have filed our, my lord, affidavit today itself, my lord.
And we have received the copy. There is no grounds of arrest that been complied with.
You have filed your reply today.
My lord, we have filed our affidavit today, my lord.
Pursuant to the order dated 27/03/2025. Planet Senior Council assisted by Mr. Consultative. Mr. P. Sharma. Pursuant to the order dated 27/03/2025. Mr. B. Sharma submitted that the state has filed its affidavit today, serving a copy of the same from the council for the petitioner. However, the said reply of the state is not available with the case record. List of 7, along with the reply to the additional affidavit. Reply of the state, the additional affidavit of the petitioner filed on.
You are supposed to file yesterday itself, my lord, as per the order.
Let it be on 17/03/2006. Okay. Mr. Sharma, no respite.
My lord.
No respite.
My lord, right. May I please, your lord? My lord,
You see the background of section 50/50A, you will know.
my lord, here 47, 48 also, no, only one line, they have only one line.
It is already annexed. The petitioners have
Already annexed, my lord, already.
Only giving you an opportunity.
My lord, my lord.
Otherwise,
We have taken that opportunity, my lord.
Right. Yes.
My lord, here item 12, my lord, we have not received case there, my lord. It was all for appearance city, my lord.
From which case, which police station?
Laluk, my lord.
My lord, today is fifth occasion.
That's right.
My lord, one thing, my lord. Last, my lord, 5 days back, my lord, I came to learn that this petitioner earlier approached this honorable court. And I have, my lord, download a rejection copy, my lord. Just 5 days back. And I filed it on 17/12/2025. And today is fifth occasion for case diary.
Okay. When that bail application was rejected?
My lord, I have obtained it, my lord. It was rejected on 4/12/2024.
And when did you file?
And I filed it 17/12/2025. And just, my lord, 5 days back, I came to learn this and I obtained this, my lord, and download this order. And otherwise, my lord, the petitioner, he is not named accused, my lord. And fifth occasion, today itself fifth occasion for case diary.
By order dated 14/02/2025.
My
This
lord,
court directed. This court observed that failing on the part of the investigating officer of Laluk PS case number 166/2024 to place the absolute case diary on the next date, I on 18/03/2025. The said officer shall have to remain personally present before the court at 10:30 AM on said 18/03/2025. However, counsel for the petitioner on 18/03/2025 at the motion stage took time. The matter is accordingly listed today. On instruction, Mr. B. Sharma, an additional public prosecutor, submitted that the concerned investigating officer have not submitted the case diary of Laluk PS case number 166/2024 in spite of the official communications. As such, the investigating officer of Laluk Police Station case number 166/2024 shall personally remain present before this court on 7th of
My lord.
April at 10:30 AM along with the up-to-date case diary.
My lord.
obligement.
Along with the officer in charge of Laluk Police Station. Yes, case diary.
My lord, case diary received, my lord.
Our MSC Som, counsel appearing for the petitioner. And Mr. P. Sharma, additional for the petitioner. MD. Well, this application and section 42 to be explained for prehending the petition. Section 42 to be explained for free and clear. Incorporate. Let me check. Please take your seat. Please take your seat. Petitioner submit that he is not an FIR named accused and the alleged explosive substances have been recovered from the house of the FIR named accused named Nurul Amin. As such, he is pre-arrest bail in seat forfeit PS case number 345 or 2024 should be considered. Earlier, the petitioner referred an anticipatory bail application being AB number 273/2024 for his pre-arrest bail in said forfeit PS case number 345/2024. And this court on perusal of the case diary rejected such pre-arrest bail of the petitioner in said such and such. This is petitioner's second pre-arrest bail application in said forfeit PS case. Peruse the up-to-date case diary placed before the court by Mr. Sharma Ladedi. As for the FIR, it is 10/09/2024 relating to the corporate appeals case number such and such. The case is that On receipt of specific information from its source, police visited the house of the FNM accused person Rakubul Islam and during search two numbers of handmade bomb, three numbers of 7.62 mm live ammunition, one detonator, and about 100 grams of plastic explosive KIR, and one surgery clip were recovered from the house of Said Nurul Amin. And he was accordingly arrested. The case diary placed before the court indicates that from the date of apprehending Said Nurul Amin in Borpeta PS case number 345/2024, the petitioner was found missing from his house, which is adjacent to the house of Said Nurul Amin, arrested accused in Borpeta PS case number 30. The statement of the witnesses, including independent witnesses and the villagers of Gagolmari village, implicated in security so far reported by the concerned state. The petitioner about the alleged crime of his involvement in said Borpeta PS case number such and such. More particular in procuring, transporting, and selling of such explosive items illegally. Considering such materials indicates that it is court is of the view that it is not a fit case to grant free arrest bail to the petitioner. Said Borpeta PS for the correct offense. Yes, you have granted interim earlier.
My lord, yes,
Yes,
yes, appeared before that. After interim, he has appeared before the IO, my lord, and statement also recorded, my lord. Lordship in the last occasion also inquired about whether he is earlier involved in such type of offences, my lord.
Heard Mr. Edeka, counsel appearing for the petitioner. And Mr. B. Sharma, additional public prosecutor, appearing for the state. Petitioner namely. Corresponding to GR number 65 of it. Petitioner is an FIR name accused in Kotwal Police Station case number 1 of 20. Under section. On receipt of specific information from source, police personnel from Samaguri Police Station at Penai Tiniali intercepted a Kia vehicle, KIA Sonnet, SONET vehicle without any number plates. On the said vehicle, police recovered one female cow with a red color milk cup and apprehended one person namely Gulzar Hussain. However, the petitioner and another namely Sadiq Ali of Juria fled from the place of occurrence, taking advantage of the darkness. Accordingly, it's a Mr. Thermal additional public prosecutor submitted that pursuant to the interim bail granted to the petitioner on 13/03/2025 in said Katwal PS case number 01 of 2025, he appeared before the concerned investigating officer of said Katwal PS case. When did he appear?
19/3. Statement was recorded on 19/3.
And his statement recorded by the concerned investigating officer on 19/03/2025. From the case there, Mr. Sharma also submitted that the petitioner is cooperating with the investigation of the case, considering such materials indicate that it is also seen that the concerned Kia Sonnet vehicle as well as the female cow and a red color male calf recovered from the state recovered and seized. Correct. Okay. Still detention with the petitioner is not one. Hello.
My lord, as per university, not there. It is done.
Yeah.
No. My lord, he was granted, my lord, he was BA, my lord. After 50 to 48 days, my lord.
If there is any material in the case, there will be.
My lord. CD is recorded. CD is recorded.
Lordship, some
This is
interim
when-
protection may be
It
granted.
is a fresh case, right?
My lord.
Bokri
From Pokraja, my lord. Bokri Bari, my lord.
Nine,
My lord.
Nine.
We'll try, my lord.
it's some 940 up to date case study. For 11 case study pertaining to Bokri PS case number 98/20. Get it.
My lord.
Or get the report whether with regard to the involvement of the petition.
My lord.
Because it was suspected to be
My lord. Meet, my lord. That is Kali Mandir, my lord. It was
nothing like this. In the bail order,
rejection. My lord. BA 503.
let's take your seat.
No.
Let's take your seat. Police station is Bogri, right?
My lord. He was behind the bar for 49 days, man.
get the case there.
Fine.
There are some materials. So
Fine.
at this moment we will not.
Fine. 9. 9.
9.